Can you sue an expert who testified against you in court? Well, let's talk about that. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Someone has asked me if it's possible to sue an expert that testifies falsely against you in either a civil or a criminal case. The answer to that, like the initials at the beginning of this channel, JD, are that it just depends. And what it depends on are the facts. Facts like where the lie occurs, whether it's in court or out of court, and whether there are damages. Let's explore that. Some experts are what I would call soft experts. For example, human factors. A factors expert is usually an engineer who examines failures and equipment or processes. And so, for example, the order taking process at Chick-fil-A. I'm certain that a human factors expert helped design that process. And when a piece of equipment that is used to cut or bind or do something that might catch a hand or a foot, the guards on those are designed by people who have studied the failures of those kinds of equipment, human factors engineers, and that's what they do. For example, a human factors expert might examine why people don't get off of an airplane after it crash lands and they wind up dying in the fire. Her job might be to try to find out how to get more people off in the future. And the reason I call it soft expertise is because there are so many different ways to approach the problems in human factors, and experts rarely agree on the best practice. So that's why they are a good person to testify, because if experts are kind of like nuclear bombs, if the other guy has one, you need one. And then there are experts who are what I would call hard experts. These are experts who deal specifically with scientific data. Scientific experts have to abide by the scientific principle. If they reliably abide by the scientific principle and they have a hypothesis, they test it, they evaluate it, and if necessary, repeat to make sure that the results are repeatable. If they have an acceptable method, if their peers approve of their work and it's published, it's pretty hard to attack them for their opinion later on. That doesn't mean it's impossible, it just means that the violations would have to be fairly egregious at that point. Now, federal courts don't require that someone have a degree in order to be an expert. Here's Rule 702, Testimony by Expert Witnesses. Notice what it says. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not that the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. That may surprise you, but it says by virtue of skill, training, or experience. So you can have an experiential expert, somebody who just has experience in a given area, and you can call them as an expert, assuming that they can pass a voir dire by the other side or a deposition by the other side and establish that they have the requisite expertise to offer an opinion. For example, suppose you had a case that involved a defectively designed highway. Instead of banking the curve in a way that would have made sense, the highway department left it flat. And as a result of that, car went off, hit a tree, somebody got a concussion, maybe got hurt bad, whatever. That's the case that you want to have an expert come in on. Well, the state is going to have the highway engineer who designed that highway come in and testify. And you could go get a civil engineer who could testify on that subject. But you could also get an over the road truck driver because they have skill and experience that makes them able to testify about what a normal road in that situation should be like and what a reasonable person would be expecting when they encounter that curve. And the over the road truck driver who's driven over thousands of miles, sometimes in just a week or so, might have years of experience that could shed light on that defective design. And under the federal rules, assuming they qualify under Daubert, they're going to be okay. And Daubert is certainly one of the things that all of the experts have to meet. If they use scientific or technical means, an expert has to meet the Daubert test. They have to have reliable methods and they have to produce reliable results. While there's more to the Daubert test than that, that is essentially at the core of it. If an expert is certified as an expert by a federal court and then testifies falsely, there's a good chance he'll never testify again. There's an even to better chance that he might wind up sitting in a jail cell wondering how he got there. Experts do not normally just outright lie, but sometimes they shade the truth. I'm thinking here of Dr. Welcher in the Karen Reed case, where he dipped his arm and turned in so that he could bounce off of the car. They don't outright lie, they just shade the truth. And that's usually written off to a difference of opinion, a difference of method, and the jury is told to give it whatever weight they deem it necessary to give it. In a criminal case, it might be very difficult to prove that an expert testified falsely. But if you could do that, your first task would be to get your conviction overturned. And if you were not convicted and you were just ticked off because the guy lied, you probably can't do anything other than report him to his professional board. While generally anyone can sue anyone for anything, the question really isn't whether you can sue the expert. The question is whether you can recover. In the case where there is someone who is convicted and they spend weeks and months in jail, they are certainly going to have damages. And those are usually economic and non economic damages. Lost wages on the economic, pain, suffering, all of that from being in a jail cell. Those are damages, real damages, and they can be quite significant. So a lawyer might be interested in taking that case, but again, the facts are going to matter. The same analysis goes into an expert lying in a civil case. If an expert testifies falsely and you lose the case, you could very well have a significant cause of action and damages. But the same problem applies. It's the facts that are going to matter. Just because someone technically has a cause of action against an expert for fraudulent statements made under oath doesn't end the inquiry. And here's why. Most U.S. courts recognize that witnesses, including paid experts, have immunity from civil liability for what they say during testimony, even if it's false. That protects the judicial process by encouraging witnesses to testify without fear of retaliation. The solution for false testimony is cross examination, contrary evidence, in other words, other experts, or criminal perjury charges, but not a lawsuit. But here's an important point. If the lie occurs outside of testimony, like in submitting, I don't know, a false resume that says that you've got a bachelor's degree when you've just been trying to get one for 17 years, that might void the immunity. Or if you submit other fake credentials, that might lose your immunity and you could face consequences for that. Expert witnesses are immune from civil liability for the truth or falsity of their testimony. But if you hire an expert and you say, I'm going to pay you $5,000, I want you to come in to court and testify that, Dr. Doe over there was negligent. And he says, okay, I got the check. I'll be there. See you then. And then he goes off on vacation to Tahiti that month. You can sue him for breach of contract and for the damages that might come about as a result. In some instances, that could include the loss of the underlying action if you couldn't get an expert to replace him. Like most things in the law, once you step into court and are sworn, you have a duty to tell the truth. And if you violate that duty, there's a very good chance you'll go to jail if it can be proved. And if you're a professional expert, you'll never testify again. You may wind up losing your professional credentials as well. Being an expert is something that I think people ought to have the opportunity to do if the possibility arises. I've been an expert exactly one time. I was an expert respiratory therapist in a case in North Dakota, and it was an interesting experience. I submitted my CV and I wrote my opinion, and I submitted it by declaration, which is the same thing as an affidavit, and as a result, the case settled. I would like to think that that would be the norm, but it's not. Usually, when you get involved as an expert, you can count on submitting to a deposition. That's just the way it goes. And then you're going to spend 2 to 3 hours being questioned about everything you've ever done, pretty much. Uh, a lot of these depositions are just fishing expeditions. So there's that. But in terms of suing them, if it happens outside of court, that is something that you can sue them for. If they violate a contract or they intentionally do something that harms your case, then again, you can go after them if it happened outside of court. But once they set foot within the parameters of that courtroom, they are protected by immunity. That may not seem fair, but that's the way it is. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.